Yes. Yes.
Yeah, I've taken the consent from PP, my lord. This matter will take up to 3 weeks. Item number 18. 18.
You're for the petitioner. Appellant. You're for
Yes,
appellant.
I'm for the appellant.
Mr.
T. Taggu. T. Taggu. T.
Tagu. Your name is there?
Yes. T. Taggu.
Okay. Tamur Tagu.
Yes.
Learned counsel for appellant Mr. T. Tagu with the consent of the other side. Praise for listing this matter after 3 weeks.
Yes.
The prayer is allowed. List this matter after 3 weeks.
Much obliged.
Yes.
Like to mention few similar pending tomorrow.
Which one?
Similar pending matters.
Pending matter.
It's a criminal petition.
Mention whether the criminal.
Criminal.
Normally, whether the mention is to be made before the senior bench or can be mentioned here.
Normally we mention here, Lord.
Used to mention here.
Yes.
Tomorrow.
Tomorrow.
What is this matter about?
Lordship, criminal petition regarding NDPS, Lordship.
No.
It was fixed after 4 weeks.
Criminal petition for
Yes.
what?
For disposal, Lordship.
What's it?
Praying for
What's in petition?
immunity under section 64A.
No, tomorrow's matter already I think is listed. List already prepared. Thereafter, day after tomorrow.
Thereafter.
Okay.
Obliged.
Hello, sir. I'd like to mention something more system.
Day after tomorrow, huh? Right. Item 16.
16. As per report, terms into this question on
Let the matter come. Are you going out urgent? No. You are for
petition.
petitioner. We'll see and pass order. Okay.
And another matter, I'd like to mention item number 19. On behalf of Mr.
19. What do you want here?
Senior is out of station.
Okay. So have you informed the other side?
For state
Mr.
lordship.
Yes.
I'm for state lordship in this matter.
He's making mention.
Lordship, no problem, lordship.
Okay. Mr. Some state.
My lord, here the conviction of 10 years order under POCSO Act passed by your lordship when you are.
Oh, then I cannot take up.
Convicted.
Okay.
Yes. So this maybe.
Okay, let this matter be listed before the appropriate court without me. Right, my name. Okay.
Yeah, like,
Your Lordship. I'd like to mention item number 10 on behalf of Mr. D. Kamduk for the petitioner.
Item,
10, Your Lordship. It's in
10.
order. Yes, sir.
what do you want here?
Your Lordship, the conducting counsel, Mr. D. Kamduk, is not present today due to some personal difficulties.
Leading counsel is not present.
Yes, Your Lordship.
You are for the
For
petitioner.
petitioner.
Have you info? Okay, this is criminal. Yes, state. State. They are making mention item 10.
yeah. Okay. This is a criminal petition, lordship.
They are asking for
Adjournment.
adjournment.
Lordship, no problem, lordship.
Okay. You are Mr.
J. Koyu. This may be listed after.
Council. Submits that his petitioner, his senior, the conducting advocate is out of the station and prays for listing this
After
matter
entering summer vacation.
after
Ensuing summer vacation.
okay, ensuing summer vacation. The period is allowed. List this matter after vacation.
Much obliged.
Miss L. Hage, L. Hage, present. Lakshmi Hage. Learned additional PP is present. Okay. Yes.
Obliged, lordship.
Obliged.
May Your Lordship, I beg to mention item number 11. Your Lordship, I am appearing on behalf of AK Singh and I have informed to the PP also.
No objection, Lordship.
Okay, Mr.
T. Nima.
Learned Counsel submits that Mr. A.K. Singh, Learned Counsel for the petitioner is out of station and praised for listing this matter
After summer vacation.
after summer vacation. The prayer so made by the Learned Counsel for the petitioner, Learned Counsel appearing on behalf of the petitioner has not been objected to by the learned additional PP, Miss L. Hage. The prayer is allowed. List this matter after the ensuing summer vacation. Okay.
Obliged, Lordship.
Yes.
Lordship, I would like to mention item number 12.
Well,
I am on behalf of the petitioner. Lordship, the ID card has not been returned yet. So we would like to seek, the ID card has not been returned yet. So some more time may be given in this regard.
May I, Your Lordship? Your Lordship, I'm on behalf of respondent number 2. Representing respondent number 2, Your Lordship. On last order dated 2/5/2024, Your Lordship, this court has directed to procure records from Executive Magistrate Itanagar. However, the report has not been received today, as per the case record, Your Lordship.
let us see what is there.
Okay, Your
The
Lordship.
last order, okay,
Yes.
past order.
In the last order, Lordship, this honorable court has directed to bring the record from the EAC through the registry of the court, Lordship.
Let us see, let the matter be called for. Okay.
Obliged.
My lord, I take the matter, item number 1. I'm supposed to find my objection, but my objection is not ready. So, my lord, I will allow 2 weeks time. Item number 1.
Item 1. You are for respondent.
Yes, private respondent report.
Okay, who is for the petitioner? Have you informed?
Yes, madam.
I'm for the petitioner, Your Lordship.
You are for the petitioner.
Yes, Your Lordship.
You are Miss.
T. Choten.
Learned Counsel for the petitioner is present. Mr. O. Modi, Learned Counsel for the respondent.
Number 4.
Number 4. There is an order.
Yes.
Okay. Praise for. How much time you want? Praise for and is granted 2 weeks time to file objection. List this matter after 2 weeks. Okay.
Back this now. May I make mention item 20. This is listed for supplementary hearing today, but then from the state side, Mr. Tado is the take up this matter. He is not present.
So
This
you want
may
this
be
matter to be listed?
listed for supplementary hearing today.
Okay. When do you want? What do you want?
Other parties are not ready.
Okay. So you know
Therefore-
that other parties are not ready.
Yes.
Okay.
So fix for some other day.
When do you want?
Any day. Also.
Okay. As prayed for by the Learned Counsel for the appellant and the respondent. List this matter after. What is this? Okay,
This is conviction under 307.
307. When do you want?
Next week, Your Honor,
Next
my
week,
lord.
after a week. Okay.
Obliged.
Obliged, Lordship.
Yes.
Item number 21.
21. Yes.
There is an application under section 227. Basically challenging my lord the manner in which the proceedings under order 21 rule 41 2 was pending before the learned student, the senior division for declaration of assets so that assessment proceedings can be carried out. Now, with great respect, my lord, the learned executing court, while that case was pending for declaration of assets, suo motu, my lord, assumes power under order 21 rule 37 and directs that we should be put to civil prison. And how can that be done? There is no application, my lord, under order 21 rule 37.
No application.
No application. There's a pending proceedings under order 21 rule 41 2. Even if there is an application, my lord, knows there are so many limitations, my lord.
Right.
How, my lord, someone can be put to civil prison?
It's a money suit.
Yes, my lord. If your lordship may kindly have some provisions of the CPC first, my lord, if your lordship may kindly have the CPC and section 51 for the moment. There is no application under by the order 21 rule 37. CPC, my lord.
Mark. No CPC.
My lord knows even when there is an even when there is an application, my lord, there are severe limitations, my lord, in a money degree how detention can be made.
Yes.
So lordship kindly have section 51 for a moment.
Ah. Section 51.
51, my lord.
Yes.
Subject to such conditions and limitations as may be prescribed, the court may, on application of decree holder, order execution of the decree. My lord, various modes are provided, A, B, C, D. My lord knows I am not going to put out this. Then the proviso, my lord, will see. Provided that where a decree is for payment of money, execution by detention and prison cell not be ordered unless after giving the judgment debtor an opportunity of showing cause why he should not be committed to prison. The court for reasons recorded in writing is satisfied. This satisfaction has to be arrived at. That the judgment debtor with the object or effect of obstructing or delaying the execution of decree
Yes.
is likely to abscond. 2. Has after the institution of the suit in which the decree was passed dishonestly transferred, concealed, or removed any part of his property or committed any other act of bad faith in relation to this property, or that the judgment debtor has or has had since the date of the decree the means to pay the amount of decree or some substantial part thereof, and refuses or neglects or has refused or neglected to pay the same, or that the decree is for a sum for which the judgment debtor was bound in a fiduciary capacity to account. So this satisfaction has to be arrived at.
Yes.
In a money decree before ordering detention, my lord. Now, my lord will kindly have order 21. Various modes of execution of my lord, a decree is provided under order 21. My lord will have
Yes.
order 21, rule 11.
Yes.
Where a decree is for payment of money, the court may, on oral application of decree holder at the time of passing of the decree, order immediate execution thereof by the arrest of the judgment debtor prior to the preparation of warrant if he is within the precincts of the court. So this was not done, so this is not applicable. 2. Save as otherwise provided by sub-rule 1, every application for execution of a decree shall be in writing, signed and verified by the applicant or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case and shall contain in a tabular form the following particulars. So it has to be a written application, my lord. What is to be that is provided? Now, my lord, to kindly have J, small j. The mode in which the assistance of the court is required, whether by delivery of any property, specifically decree, by the attachment or attachment and sale or any other sale such and such, by the arrest and detention in person, in prison of any person, by appointment of a receiver, such as that. So these are the modes. So an applicant has to come seeking from the court the mode in which the assistance is required, whether by way of attachment, whether by way of sale, or whether by, my lord, committing the judgment debtor to civil prison. So for that, there are different rules under Order 21, my lord. 11A also, my lord, is important. Where an application is made for arrest and detention in prison of the judgment debtor, it shall state or be accompanied by an affidavit stating the grounds on which the arrest is applied for. There is no application here, don't forget about the grounds, madam. Then my lord will kindly have 37. If somebody, my lord, seeks the judgment debtor's detention, my lord, then application will have to be filed under Order 21, Rule 37, my lord. My lord is aware of that. So I will not bother your lordship with it. So this is the provision under which the application has to be filed. Now, what they had filed was Order 21, Rule 41(2). I will show from the document.
41(2).
Where a decree for payment of money has remained unsatisfied for a period of such and such, the court may, on application of the decree holder and without prejudice to his owner, by order require the judgment debtor, or where the judgment debtor is a corporation, any officer thereof, to make an affidavit stating the particular of assets of the judgment debtor. This was the application that was filed. And after this, my lord, this was done. Everybody filed their affidavit disclosing their assets. It was the natural corollary was application for attachments would have been filed. And that was the order also.
So the property
Yes.
of the
There are three
judgment
judgment
debtor
debtors.
was, the judgment debtor was filed.
Yes,
Already
there are
filed.
three judgment debtors.
Hmm.
Three. Of that, two does not have property within the jurisdiction of the territory, executive court,
Hmm.
including me. My properties are all in West Bengal. So, my lord, proceedings were going against the judgment debtor number one, which is a resident of Polo Colony,
Hmm.
for attachment of his property.
Yes.
Learned executive court, my lord, to the great surprise,
Hmm.
says it's pending for a long time in issues warrant of it.
No, that can.
They cannot do that.
Hmm.
Your lordship now kindly have the petition, madam. Page 39, this is the decree,
39.
39, NHF 4.
Decree was passed in the way back in the year
Way back in, my lord, 2016.
16.
I am the judgment debtor number 3, my lord, defendant number 3, Gada Mehta.
Okay.
Now, so this is the decree, my lord, we were not bothered with this. Thereafter, just pointing out the facts, earlier also, an application under Order 21, Rule 37 was filed
Hmm.
here.
Yeah.
Then also, my lord, that is at page 45. None of the provisions of the CPC was followed. We approached the Honorable High Court, it was order of a warrant was stayed, and ultimately they withdrew the execution petition. That your lordship will find at page number 52. They found out that it was in wrong form and no affidavit, nothing was filed. No reasons was there why I should be in prison, so they withdrew it. And just pointing out, man.
Fine. Fine.
Yes,
52.
52, relevant portion is page 55. Now, in fact, appeal against the decree is pending before this honorable court.
Yes.
The issues have arisen, what the issue that has arisen now is after the coming into force of the Civil Courts Act,
Hmm.
whether the appeal will lie before the High Court or before the District Court, that issue is pending. That is the issue that has been framed by the last order. So they withdrew the execution petition, so it was closed. Learned counsel appearing on behalf of the sole respondent submitted that the execution proceedings initiated by respondent being money execution petition number such as has been withdrawn. By the said respondent, therefore, learned counsel and presence will be disposed of as the same as rendered instructions. Court clarified. It is needless to say that the validity of the warrant of arrest issued in.
This was also in the year, same year,
Yes, 2016.
2016.
So that was also not informed, so they withdrew it. The warrant also was automatically becoming valid, expired.
Now, whether this decree has been challenged,
This is under challenge, my lord. That is what I was pointing out.
what is the stage?
This is the statement. Please, last. My lord, earlier under the Bengal Agra Civil Courts Act, any appeal beyond 5 lakhs was directly before the Honorable High Court.
Hmm.
Now the Civil Courts Act has come.
Hmm.
It says an appeal from a decree of the Civil Judge Senior Division shall lie to the District Court or the High Court as the case may be.
Yes.
Nothing is provided there. So that is why, my lord, when this matter came up before Honorable Justice Suman Syam, so this point will have to be argued first. At the commencement of the hearing of this appeals, Mr. Such, appearing full on the evidence, invited the attention of this court to such more particular section 15 to submit that after the enactment of the aforesaid act, a question would arise as to whether the present appeals are required to be heard by the High Court or the matter should be remanded to the judicial district judge to hear the decision stage.
Okay.
So this will have to be resolved first. This is where it is pending. Now your lordship will kindly have page 56.
Page,
56.
what is that?
After the earlier money execution petition was withdrawn, this was filed. This is the execution petition that is pending before the Honorable Executing Court. Page 56.
Okay.
Money execution petition 21 of 2016. An application under section order 21 rule 41(2) of the Civil Procedure Code praying for directing the judgment debtor to disclose their assets, properties for satisfying the decree passed by this honorable court on such and such in money suit number such and such, such and such.
Okay, this
So
is
this is
pending.
the application,
Okay,
41(2) for declaring the assets.
yes.
My lord, thereafter, my lord will kindly have page 60. This is the first order. My lord will kindly note the money execution petition number is 21 of 16.
Hmm?
Money execution petition number is 21 of 2016. Annexure 8, my lord will find at the very top. Money execution petition number 21 2016 at the top, right hand side.
Yes,
Yes.
2160,
21,
same.
20, yes. Because just for the purpose to show it is in this application,
Hmm.
the warrant of arrest is issued.
Okay.
So by this order, 24/11/2016, notices were issued. My lord will kindly have page 61.
Hmm.
I filed my affidavit disclosing my assets.
Okay,
See respondent 2 and 3 have filed declaration in affidavit of their assets, same is accepted. Now, judgment debtor number 1, Mr. Tarpul, he did not file, so it kept on pending, my lord, for a long time. At page 63, your lordship will find that all have filed.
yes, all the judgment dates.
Yes, all have
1,
filed.
2, 3.
Yes, then my lord will see the natural corollary would have been next page. Next page, page 64.
Yes,
Heard learned counsel such and such case is adjourned for enabling applicant degree holder for preparing an appropriate application with regard to properties under attack.
this
So
was in
they
the year
should have filed an
2018.
application.
This was in the year 2018.
Yes, ma'am.
Hmm.
Because of them, they did not file and there were, ultimately it was found that judgment debtor 2 and 3 did not have properties within the territorial jurisdiction.
Hmm.
That is how it went on. So the natural corollary after this would have been, they would have filed an application if it is an immovable property under order 21 rule 54, or which is a movable under 21 rule 43. So these things were not done. My lord will kindly have a look at page 65 also for example.
Yes.
65.
Hmm.
On perusal, third paragraph,
Hmm.
it appears that some of the properties are situated beyond the territorial jurisdiction of this court. Hence, this court cannot pass order for attachment of the property situated beyond the jurisdiction of the court. Decree holder is directed to file appropriate application for the attachment of the property which is within the jurisdiction of this court. Case is adjourned. That meant JV number 1, 2 and 3. Now, this went on like this. In fact, the execution petition was dismissed for default also, my lord. I will not bother your lordship with that. These are admitted facts. My lord will kindly come to page 96.
Yes.
96. That is 21/3/2023.
Hmm.
Last, learned counsel for decree holder has submitted that there are 3 judgment debtors in the incident case, and they have been made jointly and severally liable for judgment that is substantial. Learned counsel for decree holder has submitted that out of the affidavit submitted by the 3 JDs, only JD1 has property within the territorial jurisdiction of this court. And JD2 and JD3, that is B, they have property outside territorial jurisdiction of this court. Learned counsel for decree holder has prayed that property of JD1 may be attached as per order 21/54 CPC. Further, learned counsel has prayed that JD1 may be directed to file details of his property, that is house located at Polo Colony. Hard, JD1 is directed to once again file this affidavit disclosing details of his property, this house located at Polo Colony on next day without fail, in order to enable this court to issue order of attachment. So this was the stage, madam.
This was the last order before,
This is not the last.
prior to the impugn order.
Yes, that's prior to the impugn order. Now, in fact, this proceeding is also incorrect, madam. Separate application should have been filed for attachment. That was not done. It was in the declaration of
Yes,
attachment, my lord.
after that.
This order has been passed. Now, my lord will kindly have page 97,
Yes,
10/10/2023.
yes.
Learned counsel for judgment debtor has submitted that he is unable to furnish the affidavit of assets of JD number 1 as JD number 1 is out of station on medical ground. Further, learned counsel JD number 1 has submitted that there is no medical document to produce before the court in this connection. Learned counsel for decree holder has submitted that more than a year has been taken by JD number 1 to file affidavit, and JD number 1 is deliberately delaying the execution. Notice will be issued prior to issuance of civil warrant of arrest. Third, prayer allowed, issue notice against all JDs. Now the prayer was in respect of JD1.
Okay,
Civil warrant of arrest notice issued against everybody.
okay. The petitioner is JD3.
Yes,
Okay,
JD3.
so seems the notice was issued against JD1.
Yes. This is the manner in which the proceedings are going on.
Hmm.
Then my lord will kindly have page 100. Learned counsel for decree holder has submitted the steps to issue so-called notice could not be taken, and prayed that he may be allowed to issue so-called notice against all JDs. Third, prayer allowed, issue so-called notice against all JDs, calling upon them to appear before this court on the next day and to so cause as to why they should not be committed to civil prison as per order 21/37 CPC. No application filed. This is the same money execution petition number 21 of 16 for declaration of assets.
Okay,
Then on the next day, 4/5/24, same order. Then, my lord, the second last order is page 102.
yes.
Last paragraph, I will just read. Hard allowed issue notices calling upon JDs to appear before the court on next day and to so cause as to why they should not be committed to civil prison as per order 21/37. Then this the impugn order is at page 103.
So notice was issued.
Yes. Next date was 7/6, my lord will kindly see. The fourth paragraph, hard learned counsel for decree holder. Seeing that the incident execution case is pending for long, and accordingly prayer for issuance of civil warrant against JDs is allowed. Page 103. Allowed. However, prior to issuance of civil warrant, decree holder is directed to submit subsistence allowance of ₹5,000 in favor of jail superintendent Judy Jail. Everything done. Subsistence allowance will send them to jail without any application.
Application, and then the jail also should be confirmed from the jail authority whether there is a civil prison available or not.
Yes, my lord, that is another
Accommodation,
thing.
accommodation for the civil prison.
And with that respect, even if there is an application, the satisfaction has to be arrived at in terms of section
Right.
51. Where is that, my lord? There are direct judgments on this, my lord, by our honorable High Court, by the honorable Supreme Court also. I am not going to bother your lordship with that. My lord, may kindly issue notice that is listed and stay the proceedings. This is absolutely, my lord, not.
So record would be necessary.
Yes, the court will be necessary. But prima facie, my lord, the certified copy is there before lordship. That is the last order. 7/6. Civil warrant of arrest is issued and the decree holder is directed to pay the subsistence allowance. No application, my lord. No finding, no satisfaction. Nobody is applied for my arrest. Even the Honorable High Court, my lord, exercise 230 jurisdiction cannot have been suspended, my lord. There are limitations, my lord.
Right.
He has to go by the CPC.
Okay. Mr. Vicky Pong, Land Council for the petitioner. The petitioner filed this application under section, under Article 227 of the Constitution, praying for setting aside and quashing of the order dated 7/6/2024, passed by the Learned Civil Judge Senior Division Capital Complex, UPIA, in money execution petition number 21,
Sorry, my lord, it should not be 2024, it is 2016, I'm sorry.
2016.
You correct it.
No, 21, 2016.
2016, I'm sorry, my lord.
Issue notice returnable by 4 weeks. The record of the proceeding before the trial court is also necessary. Hence, call for the scan copy
Yes.
of the LCR. Start. Yes, there's a sole respondent.
Yes, my lord, sorry.
Okay.
Decree holder.
The petitioner shall take steps upon the respondent by a registered post with AD within a week from today.
Right.
In the interim, till the returnable date, the proceeding of the money execution petition number 21, 2016 before the Civil Judge Senior Division Capital Complex shall remain stayed. So
Right.
please takes matter after 4 weeks.
Ma'am. Okay, thank you.
Hmm? 4 weeks.
Yes, please, my lord.
Yeah.
My lord, this is a prayer cell. In connection to the following case number 210, my lord. My lord, may I find if I page number 13, my lord.
My lord, I am appearing, my lord, from Guwahati in item number 3.
Item?
Item number 3, my lord.
No, this is 22, item 22.
my
Item
lord,
22.
Yes, my lord. I am appearing, my lord, item 2, my lord.
No.
Okay, my lord.
Yes, this is AB.
AD, my lord. My lord, come page 13, my lord.
Hmm?
Page 13, my lord. The FIR came from the district administration to the SP, my lord.
Yes.
May I read it?
Yes, please.
To the Superintendent of Police, Kurunkume District, Koloyan, subject FIR, in reference to the above cited subject, I am to inform you that this office has received an armed license number so and so with license holder.
What is the offense registered against?
460 that is non-valuable, forgery, and 471, that is valuable, my lord. Two sections.
468,
Yes.
where do we find?
Yes, but page 10, my lord, we come to the page 10. This is the forwarding letter by SP to the official concern on the police station, my lord. Page 10, my lord. Below my receipt.
468.
Yes, 468. What happened, my lord? This applicant,
Okay. Yes,
yes, my lord, this is the forwarding letter. And FIR is, my lord,
468 is non-bailable.
non-valuable, 471 is valuable, my lord. And 468, my lord, in my case, my lord, for better clarification, my lord, may come page 17, my lord. 117. This is the FIR lodged by the present appellant against 1 Tam Loram, my lord. May I read, my lord?
Yes.
Here, applicant is the government employee
Okay.
working at Pakistan. Therefore, this application was submitted to Pakistan. Therefore, 0 FIR, my lord. May I say, 0 FIR against Sri Tar Loram, forgery and cheating, my lord. Respected sir, with
He
due-
purchased the arms.
yes, he purchased the arm license. No,
Along
no,
with
no,
the
no, 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 in respect,
Okay.
in extent of this license, no, my lord. Because he came for the renewal of this license, then he came to know this is tech license, my lord. Therefore, he lodged this FIR against this particular person who gave him this license, my lord.
Now, this is the petitioner
This is the petitioner,
against the,
one
against one,
Tar Loram.
okay. So who is this?
This is the person who gave this license to this person, to the petitioner. my lord.
You have a gun.
No, no, my lord, I have purchased,
Purchase what?
not yet purchased, my lord.
License you have purchased from him.
License for procurements,
Ah.
some processing PS was given to him. you know.
So he obtained
Yes,
a license for you.
yes. On bona fide belief, my lord, I went for the renewal of that license because license was issued in 2000, my lord. It was issued on March.
Gun not yet purchased.
Not yet purchased, my lord, because the license was expired as per the observation of this. Therefore, they went to the Deputy Commissioner office for renewal. Then
Oh, where have you stated that?
yes,
Anywhere, where?
yes, yes. Yeah, para 5, my lord, that your humble applicant must include ways to state that the applicant has not purchased any arm on the strength of said tech license.
Okay. So
So, my lord, this is, I'm ready to cooperate with the investigation, since I have also revealed the name who this forgery has been done, my lord. So, since I am,
Or Mr. Ketari, our counsel for the. Yes,
Yes, Lordship. Lordship, as per this FIR, Lordship, page 17, this applicant, Lordship, his FIR, Lordship, that one Sri Lordship Tar Loram had given him license bearing number. This is bit weapon. Detail mention has one NP bore pistol. So, Lordship, according to this FIR, Lordship, 0 FIR, which the applicant has lodged against this person, Lordship, this is a different issue, Lordship. Here, Lordship, this bail application, Lordship, is moved for the FIR, Lordship, which is moved by the CW one Lordship, CO Lordship, which is the respondent number 2 Lordship against this person. So, Lordship, at this stage, CD may be called for, Lordship.
okay. I've also heard Miss El Hage, Lanet additional PP, Government of Arunachal Pradesh staff. Para. The accused applicant filed this bail application under 438 of CRPC for grant of pre-arrest bail apprehending his arrest in connection with KLGPS case 210 stroke 2024 under section 468, 471 of IPC. Stop. The case of the petitioner is that basing on the FIR lodged by one CW Manpung, CEO Judicial, Kurungkume District. Inter alia stating therein that the office has received an arm license number KKD stroke A 261 with license holder Sri Techi Pohi Taru for renewal. However, on scrutiny, the said arm license, the scrutiny of the said arm license, the official records and arm license and the official records, there is no such arm license number registered nor issued from the said office. And as such, the said arm license is a fake one, hence request for registration of the case. Stop. The police has registered the above PS case. What happened? Whether the police has
Lordship, page 11, Lordship.
what is there?
It's FI number 10 and dated 11/6/2024.
Page 7,
Page 11, Lordship.
11. What is it?
FI number 0010.
Okay. Register above PS case. Whether the police called you or issued any notice to you
No,
for
my
your
lord.
appearance,
No, my lord.
then
Then I am, why I'm apprehending
Hmm.
this, FIR is came from the district administration, my lord.
okay.
So SP is the SP forwarded the said FIR to
Okay,
the,
the said, okay. The land council for the petitioner submits that the said FIR has been forwarded to the SP Colorian. The said FIR lodged by the circle officer has been forwarded to the
no,
SP Colorian, who has registered the case,
no, my lord.
and
SP
hence
SP Colorian, they lodged the FIR before the SP Colorian. Then SP Colorian forwarded the letter to the officer, police station, my lord, Colorian police station, my lord.
okay. The said FIR has been forwarded to
Colorian police station, my lord, by SP.
okay.
My lord will
Forwarded
find
to
it-
the
page 10, my lord. Page 10, my lord, will find.
officer in charge
Yes, sir.
of Colorian PS by the SP. And since the complaint is, he is a named FIR, the accused applicant apprehend his arrest in connection with the above PS case, hence this application started. Issue notice, call for the scanned copy
of the
case that
case.
since Ms. L. Hage is present and accepted notice on behalf of the state, no separate notice need be issued. However, the petitioner shall take steps upon the respondent number 2 by a registered post with AD within a week from today. List this matter after 4 weeks. In the meantime, in the event of the accused applicant being arrested in connection with the Koloriang PS case number 210/2024 under section 468, 471 IPC, the accused applicant shall be released on interim anticipatory bail on execution of bail bond of rupees 20,000 with one surety of like amounts to the satisfaction of the arresting authority, with the further condition that the accused shall cooperate and appear before the eye of the case for interrogation as and when called for. That the accused shall not hamper or tamper with the evidence of, and shall not hamper or tamper with the, just a minute. So shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case as to dissuade him or from disclosing such fact to the court or to any police officer. List this matter, the earlier one, the list this matter after 4 weeks.
Obliged.
Right.
Yes. Yes. Item 2.
Someone is on PC. That's beauty.
What is it?
My item is 3.
Yes,
May I please, Lordship?
Item,
it's item 2.
yeah, man.
Yes,
May I please, Lordship? Lordship, this civil revision petition has been filed challenging the order first title ordered appellate court district civil district in session court Pasighar without giving opportunity to the caveator laws.
yes, without giving opportunity to
To
the
the
caveator,
without serving any notice upon the caveator and past the,
you file caveat.
yes.
Okay.
There is a dispute over plot of land between the present petitioner and the respondent also.
Hmm.
The present respondent, he filed a title suit before the civil judge.
Present respondent.
Yes,
Hmm.
he filed a title suit before the civil judge Pasighar, which was numbered as title suit number 14 of 2024. And in the title suit, interim ex parte order was passed, thereby restraining the defendant, present applicant, not to enter into the suit land. Thereafter, the present applicant filed a IA application for vacation of the interim order. And it was accordingly vacated on 1/4/2024.
Before the civil judge.
Yes.
Senior division.
Yes, before the civil judge. And thereafter, interim order was vacated. And against that order, the present applicant filed a caveat application before the appellate court on 3/4/2024. And what happened thereafter, Lordship?
the present respondent has filed an appeal application before the appellate court on 4/4/2024, challenging the vacation order. And on the same day, when appeal was taken up, it was moved unlisted on the 4/4/2024. And while the matter was taken up as unlisted motion, may I take you to the order? Lordship, page 170. 170. Married Lordship.
Yes.
This petition is filed under Order 41, Rule 5, 1, read it Section 141 and 151 of CPC. Filed by the appellants. The appellants herein is the present respondent also. For staying the final order dated 1/4/2024. This is the vacation order. Passed by the learned civil court of civil judge, senior division Pasigat in this case number so and so. Heard the learned counsel. In the meantime, filing assistant has also placed the caveat petition number 04/2024. This is regarding caveat regarding my caveat application. In connection with the miss case number 1424 in title suit number 1424, protecting the impugned judgment and order dated 1/4/2024. List the case at 3:30 p.m. today for hearing. Now, on the same day, Lordship, what happened? The appeal was moved unlisted on the 4th. And while taking up the appeal, unlisted motion, they came across my caveat application and saying that matter to be listed at 3:30 p.m. for hearing on the same day. In the meantime, the filing assistant said, intimate the caveator for hearing. Now, from this order, Lordship.
This was unlisted.
Yes, it was moved unlisted. And now only at the last line, it is reflecting that in the meantime, the filing assistant shall intimate the caveator for hearing. Now, after passing this order, the matter was taken up at 3:30 p.m. for hearing, and impugn order was passed at next page.
Order was passed on?
On same day, Lordship, at 3:30 p.m.
Okay.
Because matter was moved in the morning session as unlisted motion, and it was fixed for 3:30 p.m. for hearing.
You were informed?
No, Lordship, I was not informed. From the order itself, Lordship, it's reflecting that the filing assistant shall intimate to the caveator. How it could be possible, Lordship, on the same day at 3:30 p.m. when the matter was taken up in the morning session, and again it was fixed at 3:30 p.m. for hearing.
Yes.
This is a violation of 148A of CPC, Lordship.
This is civil revision.
Civil revision. Lordship.
Okay.
So no opportunity was given to the caveator, Lordship, the present petition. Now, section 148 of CPC, Lordship, to refresh. May I take you to the 148A of CPC? 148A.
148 is a caveat.
Caveat, Lordship.
Yes.
148A. Right to lodge a caveat. Clause 1. Where an application is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat in respect thereof. Now, clause 3, Lordship, sub clause 3.
You have just read 148?
Yes, 148A.
Okay.
148A, clause 1.
Hmm.
May I read again, Lord?
Yes.
Right to lodge a caveat. 1. Where an application is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge the caveat in respect thereof. That now clause 3, sub-clause 3 laws. Where after a caveat has been lodged under sub-clause 1, any application is filed in any suit or proceedings, the court shall serve a notice of application on the caveat. Notice has to be served, Lordship. But in the present case, Lordship, on the same day, appeal was moved unlisted and hearing was fixed at 3:30 p.m. and inferior order was passed.
So caveat also remain undisposed of.
Yes, Lordship. Yes, Lordship. It was first ex parte. So may I humbly phrase that, Lordship, this is a violation of section 148A 1 and 3. So therefore, Lordship, impugn order may be quashed and better be remanded back to the learned appellate court with a direction that I should be given opportunity before passing impugn order.
Yes.
Well, sometimes it is very difficult to defend the indefeasible. But then on perusal of the order at page 170, you know, for a moment.
170.
170.
Yes.
If I'm correct, 170. Well, there what happens is, it says the case was directed to be listed at 3:30 p.m., second last paragraph. And accordingly, the caveator was informed by the registry that my lord will find in the, which page? 171, my lord will see at paragraph 1, 2, 3, 4, 5. 5. As per the information received from the filing assistant, the order copy was sent to the caveator cum respondent of the case. Now here, my lord, this particular, I don't know because Lordship will accept this or not because I'm not on the affidavit. But prima facie, from this WhatsApp communication, it was sent to the caveator from the registry, Srishdhar, by WhatsApp, by the filing section of that learned court below by a WhatsApp, and has seen also case is fixed for 3:30. You know, kindly see this. And pertinently, my lord, this Kaling Mengu is a council also, my lord. It's a council. So probably the objective of 148A1 and 3 was fulfilled. But my lord, in the interest of justice, as I made a submission that sometimes it is difficult to defend the indefeasible. In the interest of justice, this impugn order may be interfered with and remand the matter back, giving an opportunity to contest the. That's fair.
Fair enough.
Because
So. just a minute, no? Okay, Mr. Yamalolen, and counsel for the petitioner. Petitioners or petitioner? Only one petitioner.
Petitioners.
One petitioner?
Two
petitioners.
Petitioners.
Okay. Also had Mr. T.D. Dara, Nara counsel for the respondent.
both the respondents.
I'll pass the order. I'll pass the order.
Correct. Great.
Yes, we have that.
Yes.
My lord,
You're right.
I am for item number 3, my lord.
Yes.
My lord, actually this case between two partners, my lord, even otherwise they are, my lord, also landlord and tenant, my lord. main accused was arrested and he was granted bail by this honorable court. And my lord, other my lord, family members of the main accused, my lord, have preferred this bail application. And where this honorable court was pleased to grant them, my lord, interim bail. And in the meantime, my lord, with the condition to pay rupees 2 crore 20 lakhs, my lord, alleged, my lord, defraud money, my lord. This matter is amicably settled. And to this effect, my lord, informant side also filed an affidavit before your lordship, ascertaining the fact that my lord, this matter is amicably already settled, my lord. And they are, my lord, admittedly not main accused, my lord. They are, my lord, family members of the main accused, and main accused was arrested, my lord, and he was granted, my lord, regular bail by this court, my lord. In view of the fact that the matter is in the meantime already compromised, man.
What is the offense alleged against the accused?
Informant, my lord, filed, my lord, one affidavit, my lord, as per my.
Informant file what?
My lord.
What is the offense?
My lord, open, my lord, as per allegation, my lord, main accused took some money from the informant, my lord, who is his landlord, otherwise, my lord, to give some contract works, my lord. But he failed to, my lord, give the contract work. But as per the agreement, my lord, he did not repay the money, my lord. Therefore, he lost the FIR. But in the meantime, my lord, he has already paid 1 crore rupees, my lord, as per the, my lord, affidavit shown by the informant, which is before your lordship. And within next 6 months, my lord, he has assured that, my lord, rest 1 crore 20 lakhs will be paid, my lord. And I have also furnished one bail order, your lordship granted on 8/4/2024, my lord, in regular bail application number 20 of 2020.
If I may, your lordship, if I may, your lordship, this is a case where to one of the accused, your lordship has granted even the bail, your lordship. This is a case where there was
One of the
accused, your lordship has granted bail, absolute. The main accused, your lordship.
okay.
The case in this, the case at present is that of cheating, your lordship, of 2 crore some amounts, your lordship. Now they have there was a direction from, since they were not cooperating, these are the co-accused, your lordship. Since they were not cooperating, there was a direction to file an IA object for vacating of the interim order. They were in interim order. Therefore, the IA was there, your lordship. There is an IA has been filed in this case, your lordship. Now, IA was for vacating of the interim order, your lordship, because they were not cooperating.
Now,
Meanwhile,
whether the accused is cooperating now?
No,
Not yet. After obtaining, please don't disturb.
Mute करके रख दो ना उसको.
After obtaining interim anticipatory bail, whether the accused appeared before the police?
They appeared, your lordship.
Okay.
Now, on the first day when they appeared, they only executed the bail. For their statement, they sought some time.
Executed.
On the execution of the bail.
So, shown arrested, release on bail.
Release on bail.
Okay,
Now,
then what
what
remains?
Thereafter, they refused to give their statement, stating that they'll come on another day because they have to leave the state. That was allowed by the IO. Subsequently, 41A notice was on many occasions was issued, your lordship. They did not cooperate. Now, the vehicle which was used for the offense was also in the name of one of the co-accused, your lordship.
Vehicle
Now,
for what? Committing what offense? Vehicle?
Vehicle. From the vehicle, all of the accused came to the house of the complainant, your lordship.
Okay.
They
What is the complaint?
Your lordship will find the FIR at page number 14. The relevant page is at page number
17.
17, your lordship.
Okay. So this is 24 against party on cheating. Okay.
So this
is
was,
that case.
yes, this was the case,
So
Your Lordship.
50 crore.
Not 2 crore, Your Lordship. The total amount,
So he was to give worth 50 crore.
yes, Your Lordship. There was, there was a promise made, Your Lordship. There were some transaction, Your Lordship. However, the subsequent action, Your Lordship.
Hmm?
Subsequent action, Your Lordship. On the day of the incident, they came to the house of the complainant. They assured that the work is at, the proposal is at last stage and therefore you'll have to pay 1 crore. Now they took, he is also a tenant of the complainant, Your Lordship. They took the
Tenant.
money, they vacated the entire rent by the morning and drove back to their place, Your Lordship. And when the FIR, and then the FIR was filed.
Total, how much amount he has taken?
2 crore
Total,
total, Your Lordship.
in different dates, on
Yes.
different dates. By case and also by,
The last handed over was 1 crore.
so
Now, if I may, Your Lordship.
is there any agreement also entered between this party also?
Yeah, not this party, the main accused, Your Lordship.
With the main accused?
Yes, with the main.
There is an
I'll
agreement.
just bring into picture how did this
Okay. Yes,
contribute,
yes,
Your
please.
Lordship. Now, if Your Lordship will see the respondent number 1, Kajibur Rahman, Abidul Rahman, he is the brother, Your Lordship. He was the one who had helped in transacting the entire money, having a link with the bank manager, Your Lordship. The both respondent number 1, 2, 3.
Just a minute, the complete this FIR, huh?
Yes,
Just a
sir.
minute, 1 minute, huh? Reach Itanagar on so and so. This was in the 2000, since 2023. Where do we find the total amount that he paid?
Your Lordship.
Total amount, where do we find the total amount he paid more than 2 crore?
Your Lordship will, if in the FIR, Your Lordship will see.
Okay, we have to calculate total. Okay, yes.
Now, what has happened was that the respondent number 1, who is the younger brother of the main accused, he has
Respondent number 1,
uh,
the
the
petitioner.
respondent number 1 in the IA, Your Lordship. Yes, yes,
Where
the
is
petitioner
IA?
number 1, petitioner
IA.
number 1.
IA is filed by the state.
State, Your Lordship.
Okay.
So page number 4, Your Lordship, I have given the entire detail about their involvement in the case, Your Lordship.
Page 4.
4, Your Lordship. Starts with paragraph 2.
Yeah.
Now, if I may just brief, Your Lordship, the
Page
respondent
4, para.
2, Your Lordship.
Okay.
The respondent number 1, that is, he had deposited an amount of 34 lakhs from the cheated money to his account, Your Lordship.
Hmm?
Out of the cheated money, Your Lordship.
The respondent number 1.
Yes.
The younger brother of the
Main accused, prime accused.
prime accused is
He has already been
in the main
granted
case
bail.
petitioner number.
He has already been granted bail in another case. He was arrested, Your Lordship, and subsequently he was granted bail.
Hmm.
Now, the respondent number 2, whose vehicle was used, Your Lordship, on many occasions, though notices were issued to him, he had not produced the vehicle till date.
There is probably no denial of having taken the money.
Yes.
Yes.
Now, respondent number 3 is the wife of the prime accused, Your Lordship, whose account was also used. Respondent number 5 is also relative, in whose account 34.
Respondent number 2 also was released.
No, respondent.
No, the respondent number 2 means the petitioner number 2.
Yes.
Same only.
Yes.
Kaji Taya.
Respondent number 3.
Also released.
No, no. Your Lordship will see IA has been filed in this bail application. So the parties are the same, Your Lordship.
My lord, with all respect, may I clarify, my lord?
If
Main
I
accused, my lord,
if I may
main
be allowed to complete, Your Lordship.
Just a minute. Huh?
My lord.
Now, we have filed an IA bringing into court's notice the praying for vacating.
In the main, whether all these.
No. If I'll just brief, Your Lordship. There were 2 bail applications. This is anticipatory bail application, Your Lordship.
Okay.
And 2 of the accused has filed a regular bail application.
Very good. No, it appears that there are 4 applicants here.
Yes.
Out of these 4?
Out of this B, where 4 of the co-accused has filed an AB together, Your Lordship.
Yes.
There were another 2 applications of regular bail application.
So that is different accused.
That has been disposed of, and
Okay.
the mail was made absolutely, Your Lordship.
Okay.
In this AB, we have filed the IA. Why? Because on many of
No, they are in this AB, whether the accused has been protected by any interim order.
Yes, there is an interim, and therefore the IA has been filed for vacating of the interim order.
No. Pursuant to the interim order granted to this applicant, whether they have appeared before the police.
No.
Never appeared.
No, they had appeared. Therefore, I was coming to that, Your Lordship. I have given in my IA that they had appeared. They have executed the bail bond on the first day. They sought permission from the IO that they'll be giving their statement on the later stage because they had some urgency to go back. It was allowed.
So
Thereafter,
then it will be a cancellation of bail only.
no, not cancellation. Cancellation is totally different from vacating, Your Lordship.
Bail already granted.
No, not granted. Only the interim was granted. During the pendency of this AB, Your Lordship, we have filed an IA for vacating of the interim order, not cancellation of the bail order, because bail has not been granted yet.
Now you said that the bail has, they appeared before the police, they were arrested and then released on bail.
Yes, because
then it has to be cancellation of bail.
No, Your Lordship. In the interim,
They are on bail as of now.
they are on interim bail, not on bail, Your Lordship. Why in this AB, Your Lordship, they were granted interim bail, Your Lordship. This is still till to this date, this is still in existence, Your Lordship. The AB, Your Lordship. Now, Your Lordship is well aware that during the interim period, there is a condition that they have to cooperate with the investigation, Your Lordship. On many occasions, even the counsel, on many occasions, they did not appear. They were giving excuses. The respondent also did not appear, Your Lordship. Taking statement only on one occasion is not complying with the interim order or cooperating with the investigation. Meanwhile, they were not producing the vehicle. They were not cooperating when called for giving their statement, Your Lordship. Thereafter, during the pendency, Your Lordship, there was a suggestion from this honorable court to file an IA praying for vacating of the interim order. So this application is to be considered for making this bail an absolute.
My lord,
Now, my only submission before this honorable court is that we have filed an IA for vacating of the interim order, Your Lordship. Your Lordship is hearing for if the interim is to be made absolute or not, Your Lordship, in this application. Now they have filed an affidavit by the complainant, Your Lordship will see, Your Lordship, that with the ground that they have made a compromise, wherein out of 2 crore rupees, 1 crore has already been handed over, Your Lordship, and rest of the 1 crore is to be given within the period of 6 months. They have filed. The informant itself, they have filed. So the discretion is upon this honorable court that my submission before honorable court is that Your Lordship may grant them bail, there is no issue. But while granting bail, Your Lordship may not take into consideration the settlement, because this settlement can be used only for quashing of the FIR, not a ground for
Yes.
granting of the bail.
Yes. So, means you are not pressing,
Because Your Lordship is hearing for the final hearing, Your Lordship. So, and meanwhile, they have also made a compromise, Your Lordship, seems they have been cooperating with the informant, in fact.
so you are not pressing further.
IA. No, Your Lordship, I'm pressing on this IA, Your Lordship, taking into consideration that the agreement cannot be a condition for
Yes, sir.
granting bail, Your
And
Lordship.
other than that,
Other than that, in my IA, if Your Lordship will kindly come to paragraph 12, Your Lordship, it is at page number 8. This was the stage,
Sarah?
paragraph 12, Your Lordship.
Hmm.
This was the ground on which we were praying for vacating of the interim order, Your Lordship.
Okay.
Now, paragraph,
Out of that much amount, 89 lakhs were seized.
yes.
Okay. This was also given on Jimma.
No, not, yes,
So-
yes, Your
so
Lordship.
this-
It has been given on Jimma, Your Lordship.
So,
Now, paragraph 13 is an interesting point where I have made my objection, Your Lordship.
yes. Sir.
Now, Your Lordship, I have also questioned the mentality on many occasions, Your Lordship. At page number 13 of the main application,
What
now
is
Your
that?
Lordship is well aware in a regular bail.
This is not the applicant.
No, it's not the applicant. Even in regular bail, a person has to give his authorization from the jail, Your Lordship.
Who
This
should check this?
this is an AB, Your Lordship.
Who is responsible for checking this?
I'm not sure because Your Lordship will see filing registry ought to have checked
Yes.
upon this, Your Lordship. Out of the 4, none of them, a person who has not even been authorized.
So you are pointing it out now.
No, I have pointed it out on many occasions, Your Lordship. The only, Your Lordship will see when the interim was given, Your Lordship. Another one of my colleague has appeared, Your Lordship. The interim was
my
given.
lord, last page is the
Thereafter-
authorization letter, my lord. Last page.
Thereafter, Your Lordship, though objections were made, Your Lordship, since I had filed an IA, Your Lordship, I had an occasion to get it down in my IA, Your Lordship.
the petitioner namely, they said the interim order says petitioners.
Yes.
So with the assumption that it was a petitioner only.
No, what I'm trying to explain to your lordship is that there has to be an authorization letter, your lordship.
Right.
In which situation? When a person is not, he is inside the jail and he is not able to appear before this court or to file or to search for an advocate, your lordship. That's when an authorization is given to any of his relative to file a case. Now this is, your lordship will consider that this is an anticipatory bail application, meaning thereby there is no restraining of them from any corner, your lordship. If your lordship will see the rules of the affidavit of the Guwahati High Court rule, your lordship, a person has to swear by his own self.
Yes. The
The
anticipated bail.
exception is
My lord,
only
this is,
given
my lord,
to
with
the
all
person
respect,
who
my lord,
asked.
this is wrong submission, my lord. My lord, High Court, my lord, this, my lord, issue was raised, my lord, at the time of filing. They registered, verified the High Court rule, my lord, and it was found that, my lord, any relative friend can, my lord. Thereafter,
Yes.
my lord, this case was passed, my lord,
That-
and this is
that-
before your lordship, my lord.
The reference he's
Wrong submission,
making,
my
the
lord.
exception is only with regard to people who are
Rule
in
is very
prison,
much clear, my
under
lord.
trial prisoners. Your lordship, if,
Can you just show us the rule?
yes.
My lord, yes, my lord, I was very much there, my lord, at the time of filing, my lord, and registered, my lord, asked me, and I appeared, and I showed the rule, my lord, before the register. Then, my
Can you-
lord, case was passed, my lord.
Can you satisfy this court also?
Yes, my lord, the High Court rule is there, my lord.
Please, which rule
At-
number?
My lord, at that time, my lord, I am in High Court now, my lord, Guwahati, but this rule book is not with me, my lord, with all respect, my lord, but it is there, my lord.
No, it's,
Okay,
My lord,
we'll fix it tomorrow. You just show us
my lord, my lord.
tomorrow or day after tomorrow.
It is
When?
there, my lord,
tomorrow,
my
your lordship,
learned friend.
even I can show it, your lordship, the reference he's making to, I can just give the notification.
We need to know.
Yes.
You show us tomorrow or day after tomorrow.
Tomorrow, my lord, it will be better for me, my lord. Tomorrow,
Okay.
kindly.
Tomorrow, no, tomorrow list already prepared. Day after tomorrow.
Day after tomorrow. Supplementary list, my lord, may come, my lord.
Yes?
Tomorrow. Tomorrow, supplementary list, my lord.
No, list already prepared.
My lord.
It's very difficult sometimes. Day after tomorrow.
My lord.
Okay. Okay, it's great for by the Learning Council for the petition. List is better again on there, again on. Day after tomorrow is
And IO is not, my lord, in this case, my lord.
20.
In the initial lordship, in the initial order, there was no direction to appear. Friend, my lord, he voluntarily went there twice, thrice appeared, my lord. Matter is compromised. My lord, money is given, my lord. Even then, my lord, IO is disturbing.
Deeply obliged.
Deeply obliged.
Yes. Yes.
My lord, this is for the post arrest bail, my lord.
Lordship, as per information, Lordship, this notice upon respondent number 2, Lordship, is victim is duly served, Lordship. So,
Just a minute. Item 4.
Four.
4, Lordship.
This is also bail application.
Yes,
Okay. Regular bail.
regular bail.
Okay. So the offense involved is
6 of POCSO actually.
POCSO.
Yes.
Notice was served.
Yes.
Okay. No one represents the respondent number 2. No one represents the informant respondent number 2. Stop. Shows that it was received.
Lordship,
Although the notice was received, it appears that the informant is unable to engage advocate to defend their case. Accordingly, the registry, is directed to appoint a legal aid counsel for the respondent number 2 informant. The legal as counsel from the panel of legal aid counsel for the High Court Legal Services Committee authority. List this matter again on. So
On 21st.
21st.
This week, Lordship, not possible. Next week, Lordship.
Next week.
Next week. Sorted.
Sorted.
Because the victim, even if they come, they cannot make submission that their role will be only under 301 to assist the PP.
Right.
If the case diary is there,
Okay. 26.
24th, my lord, Monday.
24. Okay.
All right.
Obliged.
The otherwise all records are there.
Lordship, this,
Did you
Lordship,
call for?
Lordship,
Charge sheet, you are
Lordship,
ready?
it already submitted charges, Lordship, this TCR Lordship, record may be called for Lordship. It is dear Lordship, it's already been,
Okay, it is there.
Lordship, it's received Lordship.
So the all.
On next date, Lordship, I have gone to Lordship. Next date, Lordship, the accused production is there, Lordship.
No, this is updated one.
Lordship.
Okay.
Maybe Lordship, then updated, maybe call for Lordship.
Okay, the, on which date, the Lanet Edition Public, PP shall produce the updated.
No, Lordship, the registry will call Lordship. This is the
So,
record,
no
Lordship.
registry, okay.
Lordship.
This is updated, not updated. It's
Lordship,
updated
this-
only probably.
Lordship,
Charge sheet has already been filed.
already
This is
been
charge
filed,
sheet.
Lordship.
Yes.
Lordship.
Okay, then I think that's all.
From the Lordship, yes, Lordship.
Not
It is
required.
the Lordship.
This will be retained here.
Lordship.
Okay.
All right.
Obliged, Lordship.
Item number 5.
Lordship, service upon respondent number 5 to 8 are yet to be completed.
Okay, 5, 6, 7, and 8.
8 here.
Okay. This is,
Lordship, in this matter, so far 7 times step has been taken upon the respondent.
so they are resident of,
Private response.
they are
Yes.
resident of,
Assam, Your Lordship.
They are resident of Assam and
Assam and Manipur, it seems.
then alternate service? Substitute?
yes,
7 times you have issued.
7 times.
Then I think you need to publish in paper.
And the main respondent, the complainant in the instant case, has also filed their affidavit, stating that they have no objection. Basically, these respondents were applying laborers working there at Tiribin.
What is this matter about? This is washing petition.
Washing
No,
of
you
the
publish
file.
in paper then.
Lordship may pass appropriate direction.
Hmm?
Order. Lordship may pass appropriate order.
Because you say that you have taken steps for 7 times.
If I may, Your Lordship, the respondent number 4 is only the informant.
Informant is necessary.
Informant, and they have, as per their submission, they have filed their affidavit stating that they don't have any objection. However, Your Lordship is well
And
aware,
who are these people?
they are the victims.
Victims.
Yes,
Then the victim is necessary.
yes.
Hmm.
Notice upon victims.
And in this case, Lordship, already the local kava was conducted, wherein this victim respondent were met party, were attended the kava, and they have already received the compensation amount from this respondent.
Maybe, but then we can. Let them say that they have received, they have no objection.
Lordship may pass any appropriate order.
Your Lordship, also if the service is routed through the office of the PP, that would be convenient. Because Lordship may direct them to take fresh step, Your Lordship. And the step may be, because all the steps were taken through the regular process.
Okay. Or Mr. Mr.
R. Inu.
R. Ingo, Land Council for the petition. Also have Miss Jeannie, no? Learned additional PP for the state of Arunachal Pradesh staff. No? In view of the office note dated 15/6/2024, the petitioner shall take fresh steps upon the respondent number 5, 7, and 8.
Through the routed through the office of the public prosecutor to the jurisdictional police station.
Okay. To be by a through a route to be routed through the public prosecutor.
Yes, Your Lordship,
To be served
through the jurisdictional process, jurisdictional police station routed through the.
okay. To the jurisdictional police station routed to be routed through the public PP. How long they are from Assam? Then how long it will take?
At least 4
After
weeks.
4 weeks.
4 weeks.
Least is matter after 4 weeks.
Lordship, interim is there, interim may be continued.
Their interim. Interim saying what? What is the interim?
It's saying the proceeding of trial.
Further proceeding.
Yes.
Okay, the interim order passed earlier shall continue. Think the next date.
The- Your Lordship,
This matter is pending since last 8 months, but it is still in the stage of notice.
Your Lordship, on the last occasion,
This is criminal appeal.
Yes, ma'am.
appeal. Your Lordship. We are yet to receive the reports from the concerned police
Respondent
station.
number 2.
Respondent number 2.
Who is respondent number 2?
Victim, girl.
Victim.
Victim, girl.
This is also the offense under
376.
376. And again, next, what to do? What-
My-
Resident
the-
of?
Your Lordship,
Uh,
on the last
yes,
occasion,
yes, yes.
the notice was through the PP's office. We have served the notice to the concerned police station. We are yet to receive the
My lord, the victim girl is staying here at Nahalagan itself, in
Okay.
Oju Mission.
Okay. Then Dusty.
If
Which
I am
is-
allowed to serve Dusty, I am ready.
Is it
Lordship,
allowed
Lordship,
criminal?
as far as my understanding, Your Lordship,
Hmm.
the provision of Dasti is specifically for the civil, Your Lordship. Your Lordship is well aware, even in the period
should
of
be-
notice, it has to be either through the magistrate or through the police, Your Lordship.
Right.
And therefore, my understanding of Dasti is,
So the give the proper address in the earlier step was also taken in the same address.
No,
Or
earlier
different
it was taken
address.
in another.
Now give the new address then.
Now,
present address.
now I have taken in the present address.
Okay.
I know the LCR is also received by this court. And my submission is, my lord, may I pray for appointing a legal aids counsel to represent the victim girl?
notice has to go first, Your Lordship. If
not-
they does not appear after receipt of the notice, then the stage of
Yeah. LCR have you received LCR? Okay.
Already received, my lord.
Okay.
It is pending since last 8 months.
So the last notice was taken in the present address, new address? No,
Yes, ma'am.
new address.
Yes, ma'am.
So according to you, they must have received.
They must have received.
we are yet to
I
receive
checked-
the report.
I checked
Your
the
Lordship may
report.
grant some time for
I
receiving
have
the
checked
report.
the report. It is stated that aid is, receipt of aid is awaited.
No, that is awaited. That is why I'm saying it was taken on recently only, not very of course. The case probably has come little early. June month only. Okay. Heard Mr. Esquire, counsel for the petition, and we also heard Ms. Jeannie, learned additional PP. So, the learned counsel for the petition submits that the so just a minute, the office order dated 15/6/2024 reflect that the service of notice upon the respondent number 2 is still awaited. Stop. Lana Council for the petition submits that the president submits that presently the respondent number 2 is staying in Oju Mission Nahalagan. And it will be awaited, or we want to take fresh steps?
I
Since it
will
is
allow
awaited,
the press step.
let him,
Yes,
it was through registered post or what?
last occasion.
It was earlier
The true counts, PP.
through PP. It should reach only. Now, I think.
Therefore, I was
awaited.
praying that, yes, awaited. Therefore, I was praying that
awaited.
some time for the report.
Okay, the service report upon the respondent number 2 is still awaited, huh? List this matter after 2 weeks.
After 2 weeks.
Okay, then that will do. No need to take place. Same must have gone.
Public.
Yes. Paper book ready.
Paper book is ready, Your Lordship. However, Your Lordship,
Yes.
the service is still awaited on against respondent number 2, Your Lordship.
Respondent number 2,
Yes.
step not yet taken. Who is for the petitioner? Appellant? No one appears on behalf of the petition, appellant on call. This is appeal against
Conviction of Your Lordship under under 447 and 8 of POCSO Act, Your Lordship.
Hmm?
He was convicted under section
This is also
447.
POCSO.
Yes, POCSO. In fact, in this
What is the punishment?
3 years, 6 months with a
Appeal
fine of
lies.
3 years, 6
Appeal
months.
lies.
Before this, Honorable Court, yes. 3 years
This is under
under 447, section 8.
Three seven four.
Your Lordship, under 376, Your Lordship will see where appeal does not lie. Subsection B.
374.
374 is the proviso for appeal and 376 is the exception to where appeal does not lie. Subclause B, Your Lordship will see, where a court of session or a metropolitan passes.
374 2 C. 374 subclause 2.
Yes,
Trial held by the session judge or the additional session judge. Or on the trial, or on a trial held by any other court. In
Yes.
which a sentence of imprisonment for more than 7 years.
no, Your Lordship. In fact, this was on, it was argued before Honorable A.D. Chaudhary, Your Lordship, that,
Okay.
or Your Lordship.
Hmm?
The interpretation is as such, Your Lordship, any person convicted on a trial held by a session judge or an additional judge, Your Lordship will then pose here on a trial by any other court in which a sentence of imprisonment for more than 7 years has been passed against him or her. Appeal lies, Your Lordship. exception is at page number, the 376.
That is there. What is saying this regarding this too?
376 to your lordship will see this is a this was passed by the sessions court where a court of so and so passed only sentence of imprisonment for now your lordship will see any order passed by the sessions, the appellant court is the high court, your lordship. Appeal lies because the conviction is more than 3 years, your lordship.
Anyway, so let us see then. The office note dated 2/2/24 will reflect that the petitioner has not yet taken any steps upon the respondent numbers 2. The petitioner shall take steps upon the respondent number 2 within a week from today.
Your lordship, if I may, your lordship, if your lordship only make an observation of their absence, your lordship.
I've said.
And no further order yet. Why? Because your lordship, on one of the occasion when the matter came up, your lordship, there was a direction by this honorable court to
But then they couldn't.
To not disclose the name of the victim, your lordship. She seems to be a minor, your lordship.
Okay.
That amendment has been done by them or not, that is
Right.
also not clear.
Then
Only their absence and listing the matter after 2 weeks, your lordship.
just a minute. They have implemented by what name?
The name of the victim, your
No.
lordship.
This will be difficult. How generally the notice is issued to them?
Normally, your lordship, if in such a situation, your lordship, rest of the address is clear, your lordship. The name of the victim has to be by any other words, XYZ or ABC, your lordship.
By concealing, take steps upon the respondent number 2. And since the respondent number 2 is a minor, the name shall be concealed. No?
Yes, your lordship.
Remain concealed. While rest of the address shall be is given in the petition. Okay. List this matter after 4 weeks. Okay.
Deeply obliged.
Yes.
Service is still awaited, lordship, upon respondent.
This is also criminal petition.
Lordship.
So still awaited. It was taken not very far. Okay. Mr. You are Mr.
Yes, Iram.
S.
Iram.
Iran, Learned Counsel for the petitioner. And Miss El Hage, Learned Additional PP for the state staff. The office note dated 15/6/2024 reflect that the service report upon the respondent number 2 is still awaited. In view of the above, list this matter after 2 weeks.
Right.
service upon respondent number 2 is still available.
This is criminal petition. Okay.
I prefer to wait for some time.
Wait,
Prefer to wait for
okay,
some time.
okay. Mr.
Arkoyu.
Had Mr. Arkoy, land counsel for the petition. Also had Miss Jean, land additional public prosecutor, staff for the state, staff. The office note dated 15/6/24 reflect that the service upon the respondent number 2 is still awaited. So, in view of the above, list is met after 2 weeks.
Lordship, there is interim pass.
There is an interim for what? Staying there, further proceeding?
Yes,
Okay, the interim order passed earlier shall continue till the next stage.
much of it.
Item number 12.
May I, Your Lordship?
Yes.
Your Lordship, as per last order dated 12/2/2024, this court has directed to registry to procure records from EAC Itanagar, Your Lordship. However, as per the case record, the service is still awaited, Your Lordship.
Okay. You are Mr.
J. Sring, Your Lordship.
J.
Sring,
Siri. For the,
respondent number 2.
okay. Who is for the petitioner?
Petitioner, she was present this morning.
Okay, she was present.
She was present this morning, ma'am.
Both the land counsel for the petitioner and the respondents are present. However, the report, the report by which order the record was called for?
Order dated 2/5/24. 12/2.
The record pertaining record in respect of just a minute. However, the record pertaining to Heritage versus Bamang Kaka within bracket Nika bracket close stroke 249 to the executive magistrate Itanagar Capital Complex is still awaited.
Page number 9.
In view of the above, list is matter after 2 weeks.
Page number 20.
Lordship,
Whether reminder need to be issued, I think this was not yet received.
in fact, because the record from the sessions is available if I'm not wrong. Sessions committee.
No, the record from the criminal revision from district and session judge is available,
Yes,
received.
another is with regard to the execution.
Yes. That is not, is still awaited.
I'm not very much aware of how that order is relevant because that order was in fact challenged in the
It was
revision.
called for by order dated 2/5/2024. Reminder. No, it was
23.
for earlier, and on 2/5/24, the reminder was issued.
Your Lordship,
It is a connected LCR.
not connected, Your Lordship. In fact,
Connected LCR is from the session court only.
yes, because in this, the order
This
passed
is
by,
regarding what?
order passed by land.
What is this case about? This is,
Your Lordship, this case is with regards to land dispute between two individuals.
it's a
Which,
criminal petition.
yes, criminal petition, but Your Lordship, the initial the differences was between the parties, which create a problem among society. So
this is
therefore,
quashing petition, pending
Yes.
before which court?
Your Lordship, this is a revision, the petitioner they have met in the session court. However, the revision petition was dismissed from the session court. And then they again filed a criminal petition in this, before this court.
How the case pending before the executive magistrate is connected with, or
Your-
relevant?
If
It was called for earlier, and then
It-
subsequently reminder was issued.
30, with page number 38, Your Lordship, that's the order that they are challenging. They had challenged in CRPC before the district court.
38.
38. Page 38, you know.
38. This was in the executive magistrate.
Yes, invoking power under 145.
Hmm? So this record also, is it relevant? When you're,
It's, therefore, I was submitting, Your Lordship. It does not seem to be relevant. Why? Because this order was challenged before the district court under revision, which is under challenge even in this petition, Your Lordship.
okay, so this order was under challenge before the session court.
Yes.
Okay, then this may not be required.
Yes, that.
The
that-
entire
that-
record
that-
would be available
yes.
for the session court only
Yes.
in the revision. And what do we do then? I don't know, but the petitioner is not present today.
Yes.
Petitioner would be the right person to say.
Your
that
Lordship can
this
pick
is
this
very-
matter for admission hearing.
yes, Your Lordship.
Okay. Okay, then you write their presence, presence, and the records in respect of records pertaining to the case of Heritage versus Bamang Taka within bracket Nika 249 before the executive magistrate, Itanagar. Capital complex is still awaited. In view of the above, this matter after
2 weeks, Your Lordship.
2 weeks. So let them be, let the petitioner be present.
Oblige, Your Lordship.
This may not be required, huh? Okay. This is 13. 12, no? Okay, then we'll resume it to. Any,
Can we?
yes, yes.
This 16,
Any,
17.
Item?
Item 16, 17, Milord, I was to draft a written argument,
Okay,
so could not complete, Milord.
okay.
No,
16,
16, 17,
17,
17, 18, huh?
okay. Is prayed for by Telangana Council. for the
17, 18, Milord.
Appellant.
Then let it
So,
be on
The
23rd.
other side is also present.
Yes.
Okay.
Milord.
Is prayed for by the Telangana Council for the parties. List this matter after
23rd. 23rd June. July.
23rd
July.
June.
July.
July, 23rd July.
Yes, for final disposal.
Yes.
17.
17.
Okay,
17.
okay.
And the interim to continue to that.
The, okay, just then, Telangana Council for the appellant, Mr. Titi Tara is present. Mr. Dicky Pangalan, counsel for the respondent is also present. Is prayed for by the Telangana Council for the parties. This is matter on 23
July.
July.
23rd July.
Stop, the interim order passed earlier will continue till then.
Grateful.
Okay,
Grateful.
yes,
I like to, item 16,
16. What do you want?
service notice awarded.
Okay, you are Mr.
DC vote.
Hmm?
DC vote.
D,
DD.
your name is there? Oh, appearing on behalf of T. Tapak. Then appear on behalf of T. Tapak, Telangana Council for the petitioner staff, The service report upon
Respondent number 2.
respondent number 2
to 8.
2 to 8. Okay, 2 to 8 is still awaited staff. In view of the above, list is matter after 2 weeks. 3 weeks. Okay, after 3 weeks. Okay. Then 3 matters. 4. Okay. So, very good. The service is still awaited. Not yet received. Okay. Which one return answer? Your Mr. You want to express a step? Your good name? D. Day. Or Mr. D. Day, Land Council for the applicant. How many respondents are there? Please make appeal. Okay. In view of the office note dated 15/6/2024, the Land Council for the applicant wants to take a fresh steps upon the respondents. Stop the prayer is allowed. Steps by what mean? Register post. Okay. The steps be taken by a registered post with AD within 3 days from today. So list is matter after. Their addresses are insurance company and the one is West Coming. I think it will take 4 weeks. It will take 4 weeks. 4 weeks. Okay. 14 and 15 are. This is also for condemnation. All are similar. Notice written. Oh, this is written. This has written answer in respect of one with the postal note address cannot found and the same is placed with. So address is not found. Then what do? You need to find out the No, now the postal, the report says that the address not found. Hmm? Record. Let us see who are there. It is possible address might not find because they must have changed their address also. If they are if they were working as a laborer, then must have changed their address. Or even if Mohammed Sulman. Not a permanent address. Is it a permanent address? No. So you find out the address and take steps. Here also fresh step. No, 13 is different because it was, it did not say that address not found. This is 14. 14 and 15 are same. Oh, 13 or 15, not this one. Address not found. No, this is 14 and 15 are same. Okay. Mr. D there. No? Your D there. Counsel for the applicant. In view of the office note dated 27/5/2024, the applicant shall find out the present and proper address of the respondents and take fresh steps upon them. By a registered post with AD within a week from today. List this matter after 4 weeks. All 13 to 13, 14, 15, 4 weeks. Okay.
May it please your lordship. Lordship, we have filed a CRP challenging the order of the Honorable Court of Magistrate Bomdila. Lordship, the IA has been filed for condonation of delay, your lordship.
Notice.
But no, your lordship, I'll just clarify, your lordship. In fact, I had presumed that there was a delay, your lordship. However, if your lordship will see, there seems to be no delay as per section 12(2) of Limitation Act, your lordship. Your lordship, I'll just.
Registry must have calculated.
No, your lordship. Therefore,
No.
I'll just show your lordship. The judgment was passed at page number, your lordship will see, at page number 15.
This is condonation petition only.
Yes.
Then if
Therefore,
there is no
because-
delay, then why?
Because therefore, I had the assumption that the calculation should be made from the day of the order is being passed, your lordship. But the section 12 of Limitation Act, there's an exception, your lordship, that after the order has been passed, I have immediately applied for a certified copy.
Yes.
Thereafter, I was given the certified copy on certain date, and the calculation will start from the date of the certified copy, issue of the certified copy.
Yes.
If your lordship will see at page number 15, your lordship, I'll just read, your lordship. The order was passed on 9/2/24.
Page 15.
Yes. Impugned order was passed on 9/2/24, Your Lordship.
Yes.
Immediately, Your Lordship will see at page number 20.
Yes.
I had applied, Your Lordship, above will see on 12/2/24, Your Lordship.
Yes.
And I was given
Last
this
date of, last date of the case, 12 to,
24, Your Lordship.
yes.
Now, when was I given the certified copy, Your Lordship will come back again to page number 15, Your Lordship.
Yes.
Down below, Your Lordship will see certified to be true copy was issued to me on 17/5/2024.
Okay.
So if I calculate from 17/5, those periods are excluded, Your Lordship, and therefore there seems to be no delay, Your Lordship.
Then you need to withdraw.
Yes, my only contention is, Your Lordship, if I withdraw this IA application, Your Lordship, my submission just of my mistake may be recorded in the order, Your Lordship.
Okay. Miss Virginie, non-counsel for the applicant. At this stage, Ms. Jenny submits that this condemnation petition was filed with the assumption that there was a delay of how many days?
35 days, Your Lordship. 35 days, Your Lordship.
35 days. However,
As per Limitation Act
lately
12,
she realized that as per the
Section 12,
Section 12
subsection 2 of Limitation
Subsection
Act.
2 of the Limitation Act, the limitation runs from the date of
Receipt of the certified copy
receipt of the certified copy of
dated
certified copy, stuff, In the instant case, see, the order was passed on 9/2/2024,
Yes.
and the applicant applied for certified copy of the impugned order on 12/2/2024.
Yes.
And the certified copy of the impugned order was provided to the applicant on 17/5/2024.
Yes.
And as such, there is no delay
Yes.
in filing the connected.
CRP number 23,
Connected, yeah, civil revision petition,
and therefore liberty
23 AP 2024,
for withdrawal.
Stop. In view of the above, she prays for allowing her to withdraw this condemnation petition with the liberty to.
No, not liberty.
No
Your Lordship,
liberty.
this,
Okay. 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 Withdraw this condemnation petition. Stop. The prayer is allowed. This petition is dismissed on being withdrawn.
Dispose on being
Disposed
withdrawn.
on being withdrawn. Okay.
Now, if Your Lordship will take the CRP, Your Lordship. Since the CRP also.
Now I think the CRP registered.
Yes, Your Lordship. It has
Now,
already
since
been
you-
registered and numbered.
Since it was calculated on, because you have filed, now they have to check probably.
No condonation part, Your Lordship.
So, no, the condonation part. So because they thought that since you have filed condonation, thereafter this was there.
Yes, Your Lordship.
Now they have to check if there is any condonation. So they will keep mark. I think there is.
No,
some-
no, Your Lordship.
In the, where is the tick mark being done? I think in the condonation petition, they must have ticked the column where the condonation petition files, I think,
No, Your Lordship, in the condonation filing.
where? Page 1, not properly petition. The content of petition accompanied. So the petition is barred by limitation, see? And application for condonation delay is filed.
Yes, now
So
if the,
this, they have to now tick mark no delay. Now you have to give it there.
now in
Right.
that case, Your Lordship, there has to be an order with regard to that. Otherwise, because it has already been filed and registered, it will be in the office of the registrar. Unless there is a direction for that, there cannot be any changes made in the place. Therefore, my submission was that if any condonation, even if it's disposed of, dismissed, if any in the case, Your Lordship,
Because
once
they
the-
need to certify that this is correct. That is why it can be, and says that it can be listed before the court. Okay. This is in condonation petition only. I
Yes,
think this
in-
order was.
in condonation,
Yes,
yesterday the matter had come, Your Lordship.
Okay, in view of the order pass, in view of the order pass in IA C 97 AP 2024, this CRP, it's already numbered, no?
Yes, it's.
Unless it is condoned, probably it should not be.
No,
okay,
no,
So it's
no,
fine only.
it's fine, yes.
Used number.
I'll just explain the procedure, Your Lordship. This column, if any IA is being filed, in the filing columns, Your Lordship, any IA has been filed, that is being reflected in the filing sheets, Your Lordship.
Yeah.
Now, if the condonation is allowed or dismissed, that will stay. Now, if I withdraw my condonation, Your Lordship, the revision automatically comes because it's a take matter along with the IA condonation.
In cases, says, for example, make appeal.
Yes, Your Lordship.
So in some courts, probably it is registered only when the delay condonation is allowed.
In fact,
Delay is condoned.
in fact, that ought to have been, because I remember this has been the query of the court on the previous occasion by a senior judge, Your Lordship. That in Guwahati High Court, I have practiced there, Your Lordship. Guwahati High Court, what they do is, they don't even write the, register the case.
Yes.
They just give a filing number.
Yes.
Now, if the condonation
what
is
I am
allowed, then the matter is then again listed with the proper
It will
registered
number.
number.
Numbered.
However, in the registry here, Your Lordship,
Yeah, it will be difficult because if the
it
condonation is not
registered.
allowed,
it should not be numbered. Yes.
That is why I was.
That was the query even in the by honorable
No, because
senior.
the practice is there. Practice there is that way only.
Yes.
That is why.
Yes.
Because after condonation, we give a direction that be registered and placed.
Yes. Yes.
After register only,
Yes.
not fixing the date also. Can't fix the date also,
Yes.
because after
Yes.
registration only it will come.
Yes. Absolutely. And
Okay.
in this, Your Lordship, I'll like to clarify more, Your Lordship, that in IA condonation, as I said, Your Lordship, the filing slip contains the IA any file along with the CRP or appeal, Your Lordship. Now, if even for assuming that the delay has been condoned or dismissed, Your Lordship, any change made in there cannot be, because that's just a reflection of that condonation IA was filed. Now, in my case, if I have withdrawn the condonation, and I have also for my
Then it has to be then in the IA only, the order.
the order has to be in the IA, Your
IA
Lordship.
only.
That order has
Okay.
to be also because the IA will always remain, even if it's disposed of, withdrawn, it will always remain a part of the
Yes.
court's record, Your Lordship.
Right.
Now, therefore, there cannot be any changes made to the filing slip,
Yes.
because I have withdrawn is also an order, Your Lordship. Withdrawing also is an order. There is an order for withdrawal, Your Lordship.
Yes.
Now, there cannot be a change in the filing slip. Your Lordship has just shown me the filing slip, the reference made in the filing slip that an IA has been filed, Your Lordship. That part. Because the IA has already been listed.
So the condonation for IA file, it is, there is a remark.
Your Lordship can, in fact.
430 here also, same.
Yes. This part.
So in the,
This part, we normally, there is barred by limitation 8, Your Lordship. I have satisfied Your Lordship in IA stating that there was a wrong assumption by me, Your Lordship, with regard to that there was a bar, Your Lordship. This, in this revision petition, Your Lordship,
Hmm.
even the Your Lordship can record the, that IA was filed, presuming that bar was there, however, later on the same date, it was withdrawn.
Okay. But it has to be
Because-
sent back to the registry to clarify the remark in the column 8.
No, that's why what I'm saying is the order passed, Your Lordship, the order passed in the IA itself will be a part of this record. My presumption, wrong presumption on section 12 and 5, Your Lordship. Your Lordship, in the IA has already declared, Your Lordship, that there was and liberty was given for me to withdraw it. I have withdrawn it, Your Lordship. That can also be a part of this order, this revision here. Because if Your Lordship give its weight to the registry to correct it, they'll be seeing that order of the order passed in the IA, withdrawal with the wrong perception. There cannot be any changes made, otherwise I'll have to refile it.
No. Here, probably because there is a, in that also checklist,
Yes.
for condonation, since there was a delay of 35 days, you have filed condonation petition.
Yes. Now that condonation petition, Your Lordship, the Lordship has already decided on that condonation petition. That, and my, recording my submission, that there was a mistake on my part, and therefore I had withdrawn it.
See, in that, then, so let it be listed tomorrow or day after tomorrow. We'll say, send it back to the registry
Yes.
with a remark that the registry shall do the needful.
Do the needful with regard to paragraph, point 8 of the checklist.
Okay, in view of the, that, and then, in the IA only, huh? In view of the above, the,
Otherwise, Your Lordship, if I may suggest, Your Lordship,
hmm,
if my petition is not withdrawn, Your Lordship, condonation,
hmm.
and in fact it's disposed of,
Then automatically stay, because then the record is already there that the delay condonation petition, the delay condonation petition was allowed.
yes, no, what
And
I'm,
then it will say that in view of the order,
no, what I'm trying to apprise Your Lordship is that if instead of withdrawing my IA petition, I make a submission that that part was wrong. Your Lordship, instead of that, decide on the fact that yes, there was a wrong in the provision, you know, and dispose it off. Then my condemnation petition gets away. Your Lordship, by that
no,
order,
to calculate that the registry will calculate. Registry will find out if there was any delay or not. They will clarify in this checklist,
no,
serial number 8.
Your Lordship, I'll, instead of withdrawing the IA,
Hmm.
I'll satisfy Your Lordship
Hmm.
that from where the calculation has to be made. Allow me in that situation. Then Your Lordship will decide.
Then
on the IA.
in that case, it has to be contested by the other side also. Other side.
Right, the IA, the
Other
condemnation,
side might say, no, it has to be
the
calculated.
condemnation petition is much more of the satisfaction to the court, you know. And in my case, Your Lordship will see, there is,
No, in the case, if there was a delay, then you have to satisfy the court as well as the other side also will have to have an opportunity to object.
there are instances where this court, when satisfied on the very first day, dispose of the condemnation petitions, Your Lordship.
No, without giving an opportunity to the
Yes,
other
yes,
side, it
yes.
will be little difficult.
I had in fact, made a research on that, even the Chief Justice has done the same, Your Lordship.
Then in some cases where we find that no, see, here in the
Supreme
case,
Court has different issue. Why? Because the Supreme Court rules, it says that notice has to be given. There is a specific rule in the Supreme Court rule.
Here also, without giving notice, it's very difficult. I have never seen.
In that case, Your Lordship, in that case,
And in that case, you have to show the citation.
in that case, Your Lordship, then in that case, the very, only with regard to checklist.
Checklist,
I-
serial number 8.
number
Because these now, they have to cross it, say that there is no delay. They have to take it clear. Okay, in, the, okay. In the last, huh? The, in view of the above, the registry shall do the needful and place before the, place the CRP, yeah?
Necessary change in,
Do the needful with regards to the serial number 8 of the checklist
of the CRP.
of the CRP and place before the court. Okay.
At least this matter tomorrow.
List,
Listing this matter tomorrow.
checklist and list this matter
Tomorrow, because this matter has come up yesterday also.
tomorrow. Okay. Okay.
Keep your question.
Yes.